Lesson 7. The Advocate. I will ask the Father, and He will give you another advocate to help you and be with you forever. John 14:16. The work of the advocate is not easy. You will hear stories of death, violence, disease, deep pain, regret, and betrayal. In the middle of all that, you need to be a friend and a professional at the same time. Your clients will be emotionally charged, and you will have to remain calm. They will want to do things that are not in their best interest, and you will have to push back as a good friend. In this lesson, we're going to see the practice of the advocate's work. First, we will go over some general guidelines, and then we will end the course with a rundown of the typical intervention of the advocate in the process from the first contact with your client until the end of the case. 1. Guidelines. Ministry. An advocate must be knowledgeable, confident, honest, and encouraging. Your openness, interest, friendly manner, compassion, non-judgmental, professional, and competent counsel will help put your clients at ease as you guide them through the process. The advocate is, above all, a legal advisor, but the advocate is a minister of the church as well. You will be the face of the Mother Church for the faithful. You will help your clients by listening carefully, treating them with respect and kindness, and praying with them and for them. This pastoral dimension of your mission is particularly important when it comes to helping clients to digest bad news. In the same sense, the advocate moderates the client's expectations. While you certainly can show optimism if the case allows for it, you should always warn your client that a negative outcome is possible and that we cannot know how long a particular case could last. Furthermore, advocates are mandatory reporters of any suspected abuse against children or vulnerable adults. As a requirement to become an advocate, you need to take the Virtues training, in which you will learn how to identify possible cases of abuse and how to address them. If you suspect that any abuse has taken place or is ongoing, contact the Division of Family and Children Services within 24 hours of knowledge of suspected or actual abuse, and also contact the Metropolitan Tribunal to let us know that you have made a report. Confidentiality. The information discussed in matrimonial cases is highly sensitive. Confidentiality is, therefore, a fundamental guiding principle. The general rule is to only discuss the case with your client and with the officials of the Metropolitan Tribunal assigned to your case. No one can learn from you any information that you learned in the exercise of your ministry as an advocate. This includes your own spouse, friends, and co-workers, your client's children and intended spouse, even if they are civilly married, your client's pastor, and any other clergy or parish staff, and tribunal staff that is not assigned to the case. If anyone asks, your answer should be firm and frank. I cannot speak about it. Sometimes, Catholic intended spouses of non-Catholic petitioners reach out to us asking about the development of the case. Since they are not parties with interest in the trial, we cannot give information to them. Please let them know beforehand to avoid frustrations later. When you speak on the phone with your clients, make sure you are talking to the correct person and that no one else can hear the conversation. In general, avoid texting, particularly for case-specific information. The Archdiocese will provide you with access to a dedicated email account. No other email account can be used for advocacy work. Confidentiality implies being careful with the places where information is shared and stored. Do not discuss the case in front of other people where you can be overheard. Be careful with phone and video calls. Never share case information where others may gain access to it, like answering machines, voicemail boxes, etc. Instead, simply leave a message asking to return your call. Do not keep original documents. If your client submits originals to the court, the tribunal will make notarized copies right away and return the originals to your client. If notarized copies are submitted, make sure that your client keeps the originals. On the other hand, you should keep a copy of all documents that your client submits to the court. These copies need to be kept in a locked file cabinet either at your parish or in your home where no one else has access to them. At the end of a case, shred copies of any documents that you retained during the trial. 2. Praxis. When it comes to your practical work as an advocate, two main principles should guide you. First, set the case right from the start, the right process and the right grounds. Second, do it as fast as possible, avoiding any unnecessary delays. Contact. The following is a paradigm that you can adapt to the particular needs of each case. The prospective petitioner, following the recommendation of the pastor or after finding your name on the tribunal's website, emails you. You call back, introduce yourself, and ask if this is a good time to ask a few questions. Here you do a first assessment of the case, asking how many marriages need to be addressed and the baptismal status of the parties. These first questions serve to quickly identify lack of form, prior bond, and dissolution cases. When these processes are not possible, it is usually easy to weed them out with a few questions. If you have already identified the process, email the application form to your client right away so that they can start filling it in. The quick phone call ends with an appointment for an in-person or video conference meeting. Before the scheduled meeting, the client has to create a draft of the application form and gather the required documents. If the case is difficult, the meeting will allow you to assess the case in more detail. You can also email your client a link to the video series How to Get an Annulment from YouTube. It will help them to understand the process better and could serve to identify grounds as well. Meeting. Your parish should provide you with a space where you two can meet in private. You may also meet with your client via video conference. Wherever and whenever you meet, always begin and end your meetings with a prayer. Following our paradigm, if the case was difficult, this meeting is the chance to assess the case thoroughly and to identify the right process and the right grounds. Depending on the nature of the case, it may take more than one meeting to prepare the application. If you have already identified the process, the meeting serves to review the application draft prepared by your client. Ideally, you will meet in a room with a computer so that you can modify the application draft during the meeting, making sure that the information is accurate and complete. For judicial cases, this is the time to identify the grounds. Your client's answers to the questions in the section Grounds are a simple way to do it. Whenever there are signs of a possible ground, inquire about it to make sure that the essential elements of the ground were present at the time of consent, and make sure that your client will be able to propose the right proof to demonstrate that the marriage was invalid. Indeed, finding the right proofs is as important as identifying the right grounds. As we have explained before, the right witnesses are those who can testify to the facts that render the marriage invalid. Make sure that you identify good witnesses. As with all the proofs, quality is always better than quantity. Do not propose a lot of witnesses. Propose knowledgeable ones. Make sure that your client contacts the witnesses to ensure that they are willing to help. Before the end of the meeting, explain the basic steps of the process so that your client is ready and knows what to expect. Explain in a very clear way what things are still pending, if any. Obtaining more documents, contacting possible witnesses, etc. As soon as everything is ready, you can submit the libellus to the court. Documents. All marriage cases require documental proofs. Among these, some are so important that the libellus cannot be accepted without them. On the other hand, gathering the right documents can be challenging, so instruct your client to get to work on obtaining them from the very beginning. All the documents submitted to the tribunal must be originals or notarized copies. Notarization can be done by a secular notary public or by an ecclesiastical notary. Since you are an advocate, you cannot notarize your client's originals, even if you are a notary public, because you are an interested party in the trial. A document that you always need to submit is the certificate that the marriage in question was celebrated. Both the civil marriage license and marriage certificate fulfill this purpose. For documentary prior bond cases, however, the marriage license application, different from the marriage license, is mandatory. When a baptismal certificate is requested, it needs to be recent. In practice, this means that at the time of submission, it cannot be older than 6 months since it was issued. Baptism in non-Catholic communities is not always recorded, so it may be difficult to find a certificate. In these cases, the baptismal certificate is only required when it is possible to obtain it. There may be converts who were baptized outside of the Catholic Church and then received into its full communion. In such cases, instead of a baptismal certificate, they should send the certificate of reception in the Catholic Church, also known as profession of faith. This reception of already baptized members is recorded in the Book of Baptisms of the parish where the reception took place. The civil decree of divorce is requested as well in all cases. Even though civil divorce has no effect whatsoever on the marital status of the parties, the Catholic Church is respectful of the secular systems of law, at least inasmuch as they respect natural law. We request the divorce decree for the secular authorities in order to avoid possible cases of bigamy and interference with litigations before the secular courts. For the same reason, we do not accept cases until all secular litigations are over. The decree of divorce is different from settlements and other divorce documents. The decree that you need to submit contains the judge's signature and the date when the decree was issued. There is an exception to this requirement. Some countries, like Mexico or France, do not recognize any legitimacy to canonical or religious marriage. Their systems of law simply ignore the religious fact. Mexicans, for instance, may marry canonically. but the state does not consider them to be married if they do not celebrate a civil wedding before a secular authority. Therefore, we have seen cases of immigrants who married through the canonical form in Mexico but cannot obtain a decree of divorce because the state does not consider them to be married. If you find one of these cases, just make a note for the tribunal to explain the absence of the decree of divorce. In cases where either or both parties have celebrated several weddings, it is very important to give to the court a clear understanding of the marital history. There is a special place for this in the application forms. Other than giving the information, you need to submit the marriage certificate and divorce decree, if available, of any weddings, canonical or not, celebrated by either party. In Pauline and Petrine cases, you need to prove the freedom to marry of the intended spouse. This is required if the intended spouse has celebrated a wedding previously with someone else other than the petitioner. Aside from the marriage certificate and divorce decree of each prior marriage, you need to submit the decree of nullity or the rescript of dissolution issued by the competent ecclesiastical authority. Each application form includes a list of required documents. You can use this list as a guide, but be mindful that each particular case may need other documents, depending on the facts that you need to prove. Application. Most American ecclesiastical tribunals employ fill-in forms. Our application forms are available on the website of the Metropolitan Tribunal. Now and then, we upload updated versions of the forms, so we recommend downloading the document directly from the website each time, instead of keeping a blank copy and reusing it. All our forms can be filled in on the computer. Please try to avoid handwriting unless it is truly impossible to type and print. In all cases, please print the application forms single-sided so that it can be easily processed at the tribunal. We are going to provide you with a video tutorial on how to fill in the tribunal forms, but here are some particularly important general indications. Make sure that your client only provides updated contact information. Even if not strictly required, give all possible information: address, phone numbers, email address, etc. If someone is difficult to reach, explain what is the best way and the best time to do it. Be very clear with your client. Taking care of these issues from the beginning will save time in the process. In this sense, the most important of all is the contact information for the respondent. The tribunal needs a complete and accurate mailing address. Without it, we cannot even accept the case. If the respondent's whereabouts cannot be found, your client needs to perform certain efforts to prove that it is impossible to find the respondent. There is a page for this in the application form. It is not enough to affirm that the efforts were conducted. Your client must submit written proof that all proposed efforts were pursued or a written explanation in case a particular course of action cannot be undertaken. Some processes not only require the address of the respondent, but the respondent's willingness to cooperate with the process as well. For instance, since the Pauline privilege requires proof that the respondent is unbaptized, we cannot process it without the respondent's cooperation. In other processes, the participation of the respondent may be required as well, depending on the circumstances. This is the case of lack of form, when the Catholic party is the respondent, or Petrine privilege, when the only unbaptized party is the respondent. There may be circumstances in which the petitioner has a justified concern about a potentially dangerous respondent. In such cases, we can protect the address and contact information of the petitioner. However, it is impossible to conduct a marriage case without at least notifying and allowing the respondent to participate in the process. Indeed, it would constitute a gross violation of natural law and a violation of the sacred right of defense, which would render the process invalid. Witnesses are extremely important. Do not propose many witnesses. Propose good witnesses. 2 good witnesses are much better than 10 bad ones. Propose witnesses who are willing to cooperate and who are truly knowledgeable of the facts that you need to prove to make your client's case. Before submitting the libellus, instruct your client to contact the witnesses and to confirm that they are willing to help. Your client should contact them and ask if they are willing to be deposed in person at their local tribunal. If they have questions, you can answer them, but be very careful not to coach the witnesses, since that could harm your client's case. Do not leave blank spaces. Instead, write, "I don't know," or "NA," depending on the case. There are some signatures required, both yours and the petitioner's. Make sure that you sign where required after printing out the document. For ordinary cases, the last page of the application form is the most important. This page is formally the libellus. Be mindful that a copy of the page will be sent to the respondent. Your intervention is crucial in determining the grounds that your client proposes for the case. On this page, the facts that support the grounds should be explained clearly and concisely, possibly in 1 or 2 sentences. Do not include attachments with longer explanations, and do not refer to the answers to the questions on the grounds section. In general, avoid submitting to the court long narratives and explanations. Many petitioners, understandably, want to vent and to feel heard. Your job is to listen to them and at the same time to refrain them from sending too much information to the court, which could potentially harm their case. The draft that your client brings to the first meeting is just a draft. With your help, they should create a better version, making sure that no irrelevant information is provided and no relevant information is forgotten. Once the final version of the application form is ready, all the documents have been gathered, and all the witnesses have been contacted and their cooperation ensured, make a final revision of everything and mail it to the Metropolitan Tribunal. If possible, use your parish's envelopes. The parish should pay for the postage as well. Here is our address. Archdiocese of Atlanta, Metropolitan Tribunal, 2401 Lake Park Drive, Southeast, Smyrna, Georgia, 30080. Instruction. Once you submit the application, you don't have any further procedural responsibilities in lack of form, dissolution, and documentary cases. Regardless, it is a good idea to call your client later on and ask about the process. With ordinary process cases, on the other hand, the submission of the libellus is just the first step. The court will send you and your client updates and other communications. Usually, you will receive notifications through your diocesan email account, and your client will receive them via ordinary mail. As part of your commitment to this ministry, you are required to check your advocate email account at least once a week. Our IT department recommends installing the Outlook app on your smartphone for this purpose. Do not use any other email account for your advocacy work, and do not copy other email accounts of yours, either personal or from the parish, in your emails. Some of our communications will require that you and your client take action. Even if they do not, it is always advisable to call your client and explain the meaning of the notification. You should review and filter everything that your client submits to the court and double-check with a canonist if you are not sure about the particular course of action. Make this very clear to your client from the beginning to avoid problems in the future. If you have doubts, contact a canonist of the Metropolitan Tribunal. Do not give advice if you are not certain that it is good advice. Ill advice is a source of frustration for advocates and clients. In case of doubt, always ask. When you or your client address the tribunal via email, do not include the defender of the bond and the advocate of the other party. If your request or notification needs to be communicated to the other parties, it is the responsibility of the tribunal to do so. Emails concerning the process must be directed to the notary of the case, who is appointed in the decree of joinder and signs all letters and emails from the court concerning the particular case. Make sure that you and your client include in your communications the name and protocol number of the case. Ordinary mail is usually reserved for petitions and recourses, like a request to amend the grounds, for instance. If you submit mail to the tribunal, do not address it to the judges or to the notary. Just write the address of the Metropolitan Tribunal on the envelope and include the name and protocol number on the head of the document so that the moderator of the chancery can transfer it to the respective official. All case documents that are not strictly private must enter and exit the tribunal through the tribunal's chancery. Publication. The last phase of the instruction is the publication of the acts. Encourage your client to review the acts of the case, and if possible, make the appointment to review the acts so that you can do it together. However, be very clear about the purpose of the publication. This is not the time to challenge any allegation made by the declarants. Rebuttal testimony, while common in American secular law, does not exist in the canonical process. You want to make sure that the acts of the case will provide the judges with all the elements of proof required to make your client's case. Nothing else, nothing more. If you realize that some elements are not clear, or that some declarations contradict your client's allegations, you need to study what other proofs can be proposed to the court. At this time, you may want to propose further questions for the parties or the witnesses, or new witnesses, or to submit more documents. If that is the case, work with your client on a written request so that it is mailed to the court as soon as possible. Discussion. Only second to the introduction of the case, your most determining intervention in the process will be the submission of arguments at the discussion phase of the process. When you receive notice of the decree of conclusion, you will be given 15 days to submit your arguments to the court. You will gain access to the acts of the case as well through your diocesan Microsoft 365 account. As with all deadlines, avoid leaving things for the last minute. If possible, get to work on your brief right away. The purpose of the brief is to make your client's case to the court. Therefore, the document itself is addressed to the tribunal, which has to make the final decision. The brief contains all reasonable arguments in favor of your client's stance. As the advocate of the petitioner, you will usually argue in favor of the nullity of the marriage. But other grounds may be set at the request of the respondent that your client does not favor. In that case, your legal duty is to propose arguments against that ground. The rule is to follow your client's procedural stance on each ground. In your brief, address each ground separately, always pursuing your client's interest either in favor or against each ground. Needless to say, the grounds of the case are those set in the decree of joinder, not the ones proposed by the petitioner in the libellus. In some cases, the formulation of the doubt is amended during the process, and then the grounds that need to be addressed in your brief are those of the last decree of amendment. As with all case arguments, the brief needs to be based on the law and the facts. You should not explain the canons as you are addressing the court. However, you certainly should refer to the law when it makes sense in your argumentation. You already know that what is not in the Acts is not in the world, so it must not be referenced in your brief. Personal confidences from your client, subjective presumptions, and private ideas do not belong in your brief. You have to explain to the court how the evidence contained in the Acts supports your client's interest on each ground. For this purpose, you should include references and quotations of the declarations. The best practice is to refer to the question number, and for important pieces of information referred to in declarations, give the number of the question and include the literal text among quotation marks. However, the brief is not a mere rehashing or compilation of the declarations. It must be a proper argument in which you explain how the evidence fulfills or not the requirements of each ground. To do this, you need to study the Acts thoroughly, noting down every element that favors the case you want to make. Consider the essential elements of each ground and its respective elements of proof, and see how they are confirmed or not by the proofs contained in the Acts. In particular, you need to address apparent and real contradictions found in declarations. Sometimes it is very difficult to make the case on a particular ground, either because the evidence of nullity is too compelling and you want to favor the bond, or vice versa. In such cases, you should simply propose any reasonable arguments to favor your client's stance. It is important to address the credibility of the declarants. Not all declarations have the same probative value. In the same vein, be careful not to mistake allegations with proven facts. Just because someone made an allegation, it is not proven that something happened. Keep the brief short. You probably have heard the sentence attributed to Mark Twain, "If you want me to give you a 2-hour presentation, I'm ready today. If you want only a 5-minute speech, it will take me 2 weeks to prepare." Good writers are concise. Do not ramble. Go straight to the point. Work hard on your brief so that it conveys all the arguments in a logical, concise, and precise manner. Needless to say, the brief should be formally correct as well. Use well-written full sentences and double-check your spelling and grammar. The same guidelines apply to your reply to the arguments of the other parties. You should not repeat the arguments that you made in your first brief. Instead, contradict the arguments made by the other parties, always based on the law and the facts contained in the Acts. In particular, pay good attention to the animadversions of the defenders. They will challenge your arguments, of course, but they are seasoned canonists, and you can learn a lot from them. Canon law is not a science, but an art, and the only way to learn an art is through practice. Forensic experience is the key difference between knowing the law and being a jurist. Needless to say, always keep your arguments exquisitely polite and civilized. Never imply or assign bad intentions to the other parties and officials. While these may be accepted or normal in secular courts, it is extremely improper of an ecclesiastical official. Always keep in mind the teachings of Saint Ignatius of Loyola in his spiritual exercises. Let it be presupposed that every good Christian is to be more ready to save his neighbor's proposition than to condemn it. If he cannot save it, let him inquire how he means it. And if he means it badly, let him correct him with charity. If that is not enough, let him seek all the suitable means to bring him to mean it well and save himself. Appeal. Your job does not end with the discussion phase. The sentence will be mailed to your client and you will have to offer guidance. If the sentence is affirmative, explain the time frame for appeal and what is to be expected. If the sentence is negative, your client may want to challenge the decision in court. Since this is a very delicate and transcendental decision to make, you should consult with a canonist of the tribunal on what is your best course of action, at least until you have more experience and gain more confidence.